Okay, I'm back. Now I've got a little one in the room with me, but that's okay. All right, so we were talking about that Illinois case. That would be persuasive, meaning, and here's the definition, any primary or secondary source of law which a court may rely on for guidance in resolving a dispute. So again, if I'm in front of a Kentucky judge and I don't have any case that's ever ruled in Kentucky on the facts that I need the court to rule on, I can say, Judge, there's no case in Kentucky. However, in Illinois, similar set of facts, this is what the court ruled on there. And our court in Kentucky doesn't have to follow it because it's not binding authority, but they can choose to because it's persuasive authority. Okay, so binding authority, they must follow. Persuasive authority, they may follow. All right? Now, talking about classifications of law. So these next couple of sections are just, let's continue defining the law, where it came from, but there's certain different ways that we can define it. So first off, we're going to classify it. First is substantive law. Okay, that's that first blank there on point A under classifications of law. Substantive law. Substantive law consists of all laws that define, describe, regulate, and create legal rights and obligations. So the substantive law, just think of it, it's the law with the substance in it. Don't drink and drive. Don't speed. Don't do drugs. Don't murder. The substance. Our laws that define and regulate what we can and we cannot do, that's our substantive law. Now, procedural law is point B. Procedural law consists of all laws that establish and regulate the manner of enforcing the rights established by substantive law. So substantive law, what we can and we cannot do. Procedural law, what happens? What's the procedure for when we do or do not do those things? When we drink and drive and we get pulled over, what are our procedural rights? We're getting our Miranda rights read to us. All these different things, those are the procedures that define how the substantive laws get applied to us. Okay, so that's one way of classifying our law, substantive versus procedural. Another way we can define them is civil law versus criminal law. Now, I briefly talked about this in our introduction. So civil law, people versus people, people versus companies, civil matters. Okay, we're talking usually about money damages. You've been harmed monetarily. Versus criminal law. You murdered somebody. That not only harmed or killed that person, but it harmed society. You are a threat and a harm to society, and so the state has to prosecute you. All right, so point A, civil law. Civil law defines and enforces the duties or obligations of persons to one another. Person versus person. So civil law defines and enforces, first blank is duties, second one's obligations. What are our duties and what are our obligations to our neighbor? All right, people versus people. Point B, criminal law defines and enforces the obligations of persons to society. Think of it, criminal law is always dealing with society. Commonwealth versus Denson. Criminal law defines and enforces the obligations of persons to society. Don't kill. You should not kill, can't drink and drive, you can't speed. What are your obligations to society so that you're not a threat or harm to society? And if you break those rules, the state has the right and the obligation, the duty, to punish you for those. Okay? Now keep in mind, you've got all kinds of all kinds of criminal law. You've got your local laws, you've got your state laws, and you've got your federal laws. All of them prohibit criminal acts, okay? Criminal acts are going to be prohibited on every different level, all right? So because we've got these various laws, and we've got the way that they're implemented, we've got the way they're enforced, we've got the way interpreted, there's a little thing I'm sure you've heard of before called the separation of powers. This gets you way back to Constitutional Law 101. So the separation of powers, again, because we've got so many different ways, laws are important, okay? They're implemented, they're enforced, they're interpreted. We've got to have a checks and balances system to make sure that one branch isn't overreaching of the other, all right? So when we talk about the separation of powers, we're talking about the system of checks and balances. All right, that's point A. So remember, the powers of the government, they are divided among 3 separate branches. And that's so that each one can exercise a checks and balances system on the other to make sure that one's not getting too much power. All right, so number 1, the legislative branch. What do? They enact the laws. They draft them. They create the laws. This is Congress. This is the House. This is the Senate. This is Congress coming together, implementing and enacting new laws. So they're the ones that are writing the laws. Sometimes they make sense. Sometimes they don't make sense at all. As an attorney, especially in the real estate industry, we'll see, these new laws implemented. On a deed, the full name has to be written. Well, these are usually people that aren't really involved in a real estate transaction. So us as real estate attorneys are sitting here saying, well, what's the full name? Is it their driver's license? Is it their birth certificate? Is it what they prefer to go by? Things like that sometimes are implemented and you think, why? What problem did we have? But obviously sometimes laws are very, very much needed. So agree with them or not agree with them, it's Congress who is enacting, writing our laws. Okay, so number 2, the executive branch. Remember, we're keeping a system of checks and balances. The executive branch, they enforce those laws. All right, they are the officers out there enforcing the laws that the legislator has written. Now, are they enforcing them correctly? That's for another branch to determine. But they're there to enforce what the legislator has enacted. And number 3, the all-powerful judicial branch. All right, they are interpreting the laws. And again, I would argue it's the most powerful branch, because if the legislature says, here's the law, and the executive branch says, all right, we're enforcing that, then the judicial branch comes along and says, well, we're going to interpret that. Now, do they always interpret it the way that the legislature enacted it or what they meant when they enacted it? Probably not. But that's why we have a system of checks and balances, separation of powers. One checks on the other. So you've got legislative branch writes the laws, executive branch enforces the laws, judicial branch interprets the laws. Okay? Now, Commerce Clause, and we could spend a whole semester talking about the Commerce Clause, but we're going to spend just a couple minutes talking about it here because we've got a lot of other material to cover. But I posted a video in the Blackboard shell. I hope you will take the time to watch it. We will probably still watch it in class because I think it's pretty fascinating and it hits home on a lot of topics. But it talks all about the Commerce Clause. So, Commerce Clause is found in Article 1, so Roman numeral 1, Section 8 of the U.S. Constitution. All right, those are your 2 blanks. Commerce Clause found in Article 1, Section 8 of the U.S. Constitution. Point A, the Commerce Clause empowers Congress, so remember the people who write the laws. It empowers Congress, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes. All right, so the Commerce Clause empowers Congress, who writes the laws, to regulate commerce with foreign nations and among the several states. Now, among the several states is where people strongly differ on what that means. When we say among the states, what do we mean? And it really becomes a political issue. You've got one side that wants, states. They want states to have more power. If the federal government does not expressly have the power to do something, then the states have the power to do it. And that means that they have the power to regulate trade within their states. On the other side, they say, oh, well, no, if it affects commerce among the states, meaning across state lines, then the federal government has the right to enact laws and regulate it. So, point B, is where it gets a little, it shows you where the judicial branch is all powerful. Point B, the Supreme Court, so the United States Supreme Court, has interpreted the Commerce Clause to permit Congress, the people who write the laws, to regulate both, number one, interstate commerce, I-N-T-E-R-S-T-A-T-E, commerce, and number two, intrastate commerce, I-N-T-R-A-S-T-A-T-E. So the Supreme Court, so let's back up. Congress, who writes the laws, they wrote, so the Commerce Clause. Commerce Clause says, in the United States Constitution is where the Commerce Clause is found. But the Commerce Clause says that Congress can regulate commerce among the several states. So the Supreme Court, who's interpreting the law, who's interpreting the United States Constitution, has interpreted it to say that the Commerce Clause permits Congress to make laws, to write new laws, enact new laws, both, number one, that affects interstate commerce, meaning interstate, think of the interstate, connects all the different states, meaning state to state. They can regulate interstate commerce, but they can also regulate intrastate. So that means inside the state. They can also regulate commerce in any given state as long as it substantially affects interstate commerce. And I know I'm doing a lot of this. I wish I had a blackboard. But so it would make sense that the Congress, our federal, United States Congress, they can regulate interstate commerce. What's happening among all of the states? Because we're talking about nationally. But the Supreme Court has said, well, you can also regulate, federal government, you can also regulate what's going on inside any given state if you can show that it affects what's going on outside of the state. Okay, so all you have to do, Congress, in order to regulate intrastate commerce, what's going on commerce-wise within a state's borders, as long as you can show that it affects interstate commerce, what's going on nationally. So, as you can imagine, this has caused quite a political debate because there's this, it's out there that all powers not specifically delegated to the states, to the federal government are reserved for the states. So some people say, okay, Supreme Court, no. You cannot have, you cannot mean that. You cannot mean that the federal government can regulate what's going on inside of a state because that power is reserved to the states. On the other side, you've got people saying, oh, no, federal government can regulate what's going on in the state's borders because it might affect what's going on outside of the state's borders. Huge political divide. And where it really falls is on some issues that are pretty hot topics. So you'll see there's a video that I've put on Blackboard on YouTube. It's called Wheat, Weed, and Obamacare. Yes, I said it, weed, because there's a lot of discussion about the legalization of marijuana. There's also a lot of discussion, obviously, in the last 10 years about Obamacare. And so this is called How the Commerce Clause Made Congress All Powerful. So it's going to give you some examples, and you've got one man on one extreme one side and the other on the extreme other side, where they're giving their positions and almost making an argument to the judge, to the people, about why Congress can regulate these activities inside of the state. And the other guy says, no, that was way overreaching of the Supreme Court. That could not have been what the Constitution was written to mean. We should interpret it then, not now. So it's pretty interesting. Take the time to watch it now. If you don't have time, we'll probably watch it again in class because I really want to kind of dissect some of the issues that they'll talk about. Okay, so I'm going to stop there for the first part of Chapter 1, and then I'll pick back up on the next video to finish the rest of the lecture outline. So save your questions for class because I'll be happy to discuss all this more. All right, later.